David Katz, everybody.
Hi, great to be with you.
Great to see you, David. And just this morning, Sidney Powell issued a plea agreement, or she made a plea. You can tell me what the official wording would be. She pleaded guilty, and I'm wondering if you could tell us what she's pleaded guilty to, because I think there are also some other charges she hasn't yet pleaded guilty to, and then what kind of deal she made, and whether or not, I was saying it doesn't seem like a very, like she got a good deal from what I can see. What is your thought?
Well, she certainly got what people would call a slap on the wrist, or in the words of the Republican House before chaos descended, a sweetheart deal. But this was sweeter than any sweetheart deal, because I told people that I thought that the prosecutor down there in Atlanta, Georgia, in that state case, was being, overly aggressive and almost threatening when she announced right after the charges that people could get 5 years in prison. And she emphasized that it was a mandatory minimum case, which was to say that people had to get 5 years in prison. And now, she agreed, Sidney Powell did, to cooperate with that prosecutor down there in Atlanta, Georgia. And all of a sudden, it's not a felony, Mark.
No, that's exactly right. 6 misdemeanor charges and 12 months of probation for each count.
She doesn't have to go to that terrible prison down there that, everybody was complaining about and saying, oh, my God, those people, they're going to face time in that prison down there. Well, she's not going to serve 5 minutes in that prison down there. And of course, this is the classic case where the prosecutor says you should believe Sidney Powell. I don't think she knows very much about Trump, so I don't even think they're getting much benefit out of making that plea agreement with her, but they're getting rid of her as a defendant in the case. That's one less person to try. And the irony is that she's one of the people who asked for a speedy trial, Mark. So, and that kind of messed up the strategy of Cheeseborough, who is going to trial. In fact, his jury selection starts tomorrow.
That's the other attorney, her co-defendant.
He asked for a speedy trial. He had one. Apparently, he's not going to take a plea deal. He's before this case, certainly a reputable, well-respected attorney whose career will obviously be destroyed by a conviction in this case. I don't think Sidney Powell really had much of a future legal career that was worth very much. But this fellow who went to Harvard Law School, worked on the Gore dispute with Bush back in the day, I think he's very worried about his legal reputation. He's going to go to trial. So I guess my thoughts on Sidney Powell was that it's actually probably net good for Cheeseborough not to have to go to trial with her. That can focus just on the Cheeseborough charges. They're again going to try to prove this whole racketeering conspiracy, which I think of as this sort of monster. They're going to show all of these things that happened in all these places by all these people for months. And then they're finally going to get to Cheeseborough and say, hey, you were part of all of this because you worked on the slates. And of course, it's going to leave a very bad taste in the mouth of the jurors, and I think be prejudicial to him that they're allowed to put on this whole racketeering case. But their argument is it's not the usual balancing between prejudicial and probative, that having charged this racketeering conspiracy, the prosecution has a right to put it all on against any defendant who they claim is a part of that racketeering organization, and then prove the very small part that admittedly that person played, admittedly by the prosecution, but they say they're entitled to put it all on as irrelevant and as prejudicial as that whole mass of evidence is against the person. But I think that the jury is usually pretty clear-eyed, and they'll see that, you know what, this all affected other people. Let's look at what he did. And Mark, what he supposedly did was he said that these were qualified slates of electors, and he should have known well enough to know, with his legal experience and the language that he used, that they were only qualified by Republican operatives. They were only qualified by the party that wanted the Republicans to win. They weren't qualified by law. They weren't qualified by any legislature or any judicial order. And that to palm them off as being really qualified slates who could go to Washington and who could be heard, who could be allowed to vote, who could have an effect on Vice President Pence, he knew enough. But they have to prove it beyond a reasonable doubt. And I'm sure he'll put on an able defense. It'll be on television, and I'm looking forward to seeing it. I hope it's on a TV station that I can get during the day or at night after work.
It'll be streamed. I'm sure it'll be available. The the whole thing with the fake electors and then the tampering with voting machines. I mean, there's a lot here, David. This is a really nasty thing these people were trying to get away with.
Mark,
And
no doubt about it, but I don't think he's charged with tampering with the machines. I think that was just Powell. And so
that's
while
right.
that may still be part of the overall
Sorry.
racketeering conspiracy, his lawyers will say he had nothing to do with that, just like they'll say he had nothing to do with other stuff that you've had to listen to for weeks, ladies and gentlemen of the jury. He had nothing to do with that whatsoever.
I see, right.
That's still a telling point with the jury, that was all very nice. There are a lot of problems in America. A lot of people at Cheesebro didn't even know, did a lot of things. But you know what? Let's focus on the man in the courtroom.
That's it. Yeah, I can tell you're a good defense attorney. So if Powell is, boy, hip deep in so much of that I've just talked about, the fake electors and the, talking about the voting machines, and I was talking about the bogus theories that she was serving up with Venezuela and all this other stuff. She said a lot of things to sort of muddy the water about the election, to be kind about it. And she's only getting a slap on the wrist. Is there anything you can look at to sort of suggest from that others who are involved in this may not be treated so harshly?
Well, that's the system that we have. It's not so much in the federal courts. What normally would have happened to her in the federal courts, let's assume she was charged with 4 counts, and on all of them, she could have gotten 5 years in prison. The feds probably would have picked 1 count that you could only get 3 years in prison for. So her lawyers would know the worst that could happen to her is 3 years on 1 count. And then the plea agreement would have been that the government will bring to the court's attention how much she cooperated, whether it was valuable, whether they thought it was truthful. But the ultimate decision, whether she got straight probation or up to 3 years in prison, would be up to the federal judge. And then you could argue in front of the jury when the defense attorney, like I am now, will inevitably say, if they're any good, this person would have said that juror number 3 was part of the conspiracy in order to get straight probation and not have a felony, not serve 1 day in jail. They would have ratted on you. They would have made up stuff on the other person. How can you believe a word they say? Then the prosecutor can come back and say, you understand that the person who's going to decide your sentence is not me, but the federal judge sitting up here. And then everybody looks at the federal judge on high in the courtroom, and the jurors think, you know what, it is going to be up to the judge. And that becomes a legitimate argument to make because of the way the plea agreement is usually written in federal court. But this one, as long as the prosecutor says that the prosecutor believes that Sidney Powell was telling the truth, that the deal holds and that she will get probation and not serve a day and only have a misdemeanor. And so expect that'll be, again, I don't think she's going to testify against Cheesebro. But if there's a case that she would testify, and of course people are looking ahead to the Trump case, she'll be able to testify about meetings she had with Trump. Remember the Stormy meeting where he's trying to put her in as a special counsel, special prosecutor to go after all the people who stole the election. Well, she could tell about that. And if Trump whispered in her ear and said, I know this isn't kosher, but, the Democrats would have done this to us. Let's do it to them. And then Trump will say he never said that. And if she can corroborate something like that, she's a great witness. And if she can't, they're going to say she's a stone cold liar who'd say anything in the world to try to not go to that awful prison down in Atlanta.
Well, that lays it out. You mentioned Trump. David Katz, Trump's strategy appears to be just to kind of slow the process. I wonder if you could speak to how that's done legally without, and getting away with it without running afoul of the court. He was also given a warning by the judge yesterday. I guess he was speaking sort of loudly, and the judge said, "Hey, dude." She didn't say dude, but she said, and she kind of warned everybody in the court, keep your voices down.
Well, yes, that's plain vanilla. I think that was the judge in the male judge in the New York City case.
Oh, okay. It was a guy. Okay, yeah.
And that's just something you can't do. And you can't sort of stage whisper. I've had clients try to do that, and of course, people have that reaction, whether it's genuine or not, when someone says that was the man. What defendant isn't going to say, or not me? And then start gesturing in their hands or talking to their lawyer. And if it's loud, and first of all, the grimacing, the gestures, a judge may very well put an end to that and say, stop with the pantomime, stop with the acting out, sit there. But, you see a lot of that, of course, it's kind of human nature. And then with the people commenting, if you comment loud enough, if it's really a stage whisper, a judge is going to say, hey, keep it down. You'll have a chance to testify, but it's not now. But I think what's interesting is the gag order. I actually had the privilege of having dinner with a couple of other people with Dean Chemerinsky last night. He's the dean of my law school at UC Berkeley Law. He also wrote an editorial in yesterday's Los Angeles Times, pointing out basically that while he wishes that Trump would shut up a lot more than he does, to order him to shut up, to issue a gag order, he thinks that the court in Washington, D.C., the federal judge there, that she went too far. And there's a famous case regarding a Democratic congressman. His name was Ford, and he was in Tennessee. And when he was running for re-election, he was also being charged with corruption, and there was a gag order placed against him. It went up to the Court of Appeals, and the gag order was thrown out. It was the main case that the lawyers for Trump argued why this judge should not impose a gag order. And they quoted Thomas Jefferson. They talked about the fact that the judicial branch shouldn't get involved in telling, in that case, a member of another branch of government, the legislative branch, what he couldn't say, even in regard to the trial that was pending against him. Now, of course, Trump is not, while he was in the executive branch, he's not a current office holder. But you could see where it certainly applies to someone who's running for the presidency and seems to be the leader for the Republican nomination at the moment. One of the things about her order that was troubling to Dean Chemerinsky and is troubling to me was the language is a little imprecise. It says that Trump is not supposed to target members of the prosecution team and the court staff. So let me give you a few examples. Now, you can't lie. You can't defame somebody. If you defame somebody in the government, they can sue you like anybody else. But, one of the great things about this country is that you can have very vocal, you can have vitriolic criticism of the government. That's something you don't have in a lot of other countries. But you can have it here. And Trump is vitriolic. But the question is this beyond the First Amendment? You take some of the examples. He says that the prosecutor against him is deranged. You and I can sit here and say the prosecutor's deranged. We can say that some federal judges around the country are in the bag. We can call cannon loose cannon. Why couldn't we do that if we were on trial? Why can't Trump do that while he's on trial? He says that the judge, who I think is highly respected, and I think that she's very competent, but he says the judge who has his case is, what does he call her, Obama hack, an Obama hack. Well, I mean, you can go around and you can say that there's a lot of judges who are hacks. I'm about to tell you that the judge who just issued the ghost gun decision down there seems to me like a total hack and totally in the bag for the gun industry. Now, if I were down there in his courtroom and I was a defendant, why couldn't I say that about him? Why couldn't I say the exact same thing about him? And worse, it wouldn't be very much in my self-interest. Now, as the lawyer, if I was the lawyer for the person in his courtroom as a criminal defendant, there are well-established rules that a lawyer can be prevented because we're officers of the court and so forth. We can be sanctioned, we can be punished. So we can't exercise our full panoply of First Amendment rights. Let me give you one more example. The court staff. Let's assume that it was, it's 4 years from now. It's Newsom running for office. Newsom's ahead in the polls. He's running against DeSantis. He's running against the third time Trump seeking office. So now it's Newsom. And Newsom gets charged with something. It's going to be in Texas in federal court. It's going to be in Idaho in federal court. And right during the election campaign, just this point, about a year before the election, Newsom is charged. And Newsom finds out that all of the law clerks for the judge who's prosecuting him did terribly in law school. And they're all members of the Federalist Society. Can he not say that? Can he not comment on court staff to say those things? Now, if they weren't at the bottom of their class, he's defamed them, right? And if he's gotten their transcripts by some kind of hacking or improper thing, he's broken the law. It's not that he's broken the gag order. It's that he's broken whatever law he did, or he's defamed them. And the other thing that I think is that she has to be worried, and this is Dean Chemerinsky's comment too, about the remedy. Is she really going to put him in jail if he violates her order? To make an order that doesn't have any teeth is sort of worse than nothing. So the next time that they come to court and they say that he violated it, what's she going to do? Now, I think what she's going to do, if it's bad enough, is fine him. I think it would be playing into his hands. And I think she'd realize that if she locks him up, even for a day or for an hour. So she could find him. And of course, he'll portray that as just, more of the deep state going after him, another Democratic African-American judge who doesn't like him, whose friends don't like him, trying to stop him from winning the presidency. So I think that it's fraught. He's appealed it already. And he has a right to appeal it. It's in what's called an interlocutory appeal, but he's entitled to not wait until the end of the case. And so we'll be seeing soon. I think am I 16 for 16? So I'm throwing my.
You're pretty strong, I got to say.
I may be going 16-1, but I think that the order will not be thrown out completely, but I think it will be greatly modified and watered down by appellate court.
If you're just joining us, David Katz, one of his superpowers is not only legal analysis, but it is these insanely accurate predictions as to what's going to happen in various judgments and trials.
There's never been anything like this.
Yeah, there really hasn't. David really brings the heat. So this is his latest one. He thinks that the gag order will be modified. You mentioned the ghost gun thing. But before I get into ghost guns, is there anything else about Trump that I was talking about the slowing down of the whole process? The idea of just kill the clock is what Trump is trying to do in all these different cases. Do you agree with that? Do you agree with that being the strategy?
Well, let's take the easiest one, the one in New York, the criminal case in New York about paying hush money to the porn star, where Michael Cohen and Stormy Daniels will be key witnesses in that case. That's supposed to go sometime in the late spring. I just don't think it fits. I don't think there's time for it. I think it'll get continued just on the basis of it doesn't fit with all the federal cases and other cases that are.
So that'll automatically be pushed, so he doesn't need to worry about even delaying that. Okay.
I don't think so. I think the civil cases, they'll go forward. He doesn't need to be there for the civil cases. And so like the E. Jean Carroll, Redux, this case that he's in right now, this case will go to its conclusion about his overvaluing his assets for getting loans and is undervaluing them to pay taxes on them. That case will go forward to completion. The case down in the Southern District of Florida, in front of the one that we lovingly call Loose Cannon.
That's the document case, yeah.
Yeah, I think she's made clear that the Mar-a-Lago documents case, she's been yelling at the special prosecutor. She's been finding fault with all sorts of things. She'll punt that case for them past November 2024. The Atlanta case, I don't think with the amount of, someone's going to go to trial now for 3 or 4 months. Then there'll be another ground. Then, so I don't think they're ever going to get Trump to trial by November 2024, which leaves him with the case in D.C., which I think really is on track. I think that judge will do everything on the idea that it is in the public interest for someone who's running for president, for the public to know whether the jury thinks he's guilty or not guilty. I think that same argument applies to Senator Menendez before he runs for re-election. The public has a right to know. And she will basically say that interest, that public interest in us knowing, in it's being decided, is more important than the private interest that Trump might like to have more time. And that when Trump argues, my lawyers just couldn't do it, they had to appeal you on the gag order. They also had to do this. They had to do the other thing. She can say you can appeal as much as you want. You can bring as many motions as you want. But that March date is firm. And I mentioned this before. I think that they will show meticulously all they did to try to get ready. And then they'll go to the appellate court and say, look, we had these Herculean efforts. We still couldn't get ready. The Speedy Trial Act is not to make you go to trial. It's not a rush to judgment act. It has exclusions, and we're within the exclusions. He needed more time. And then the appellate courts, who are conservative, because he'll get to the U.S. Supreme Court, I believe, on that claim. I think that they'll rule 5-4 for him, that he did indeed need more time.
Wow. So at the end of all of that, it is ultimately the appeal will be able to, you can kick that can down the road, but you think the Jack Smith trial on J6 for Trump, that will proceed on schedule?
I think that one's about 50-50. I think that the judge there, Chutkan, will do everything that she can to make it go forward. She'll say to Trump, look, if your 7 lawyers weren't enough, hire 17 lawyers. You could afford it. Hire one for your appeal, hire one for your motion, hire one to do the other thing, but this trial is going to go. And the only way I think they can disturb that date, pending some disaster that we haven't thought of, but is to go to in January, make a motion for a continuance, say, look at all the work that we've done, all 7 lawyers, or however many there are in the case. We've done everything that we can. We still can't get ready. We haven't had time to interview these witnesses, to brief this, to do this jury study that we want to do. And she'll say, no, you could have hired more lawyers. You had plenty of money. You knew when it was going to be. And from that order, in about January of next year, he'll go first to the D.C. Circuit, and then he'll try to go to the U.S. Supreme Court.
Right.
And he'll say, look, my rights are being violated. This is a rush to judgment. Here's the 12 things that I needed to do. I didn't have time to do them. And I think the Supreme Court will say 5-4. But that one's very, very tough. And that also assumes that Trump is on his way to get the nomination. If he falters, and this is why he wants so badly to get the nomination for president, if he falters, I think it'll be a totally different calculus.
Sure, because then now you're not dealing with a presidential candidate anymore, of course, yeah. So this is really interesting, David, because I didn't understand, and I guess you've really made it clear how the appellate process itself, it can have so many layers. All of those systems that are associated with that appeal that you just described, not to drill down too far on this, but I'm just curious, is the appellate process itself slow? I mean, how many months will all of that take that you just described?
They can expedite the decisions. And there was a lot of criticism, of course, during the Trump administration, that it seemed like that all of the appeals got slow walked if they helped him. Trying to get his tax return took 2 years, took 2 trips to the U.S. Supreme Court, 2 arguments in the U.S. Supreme Court. And then by the time they finally got his tax returns in the Congress, you remember, it was years after they started trying. And so the appellate process can be very fast. Cases can be expedited. And so I think that there would be a decision. I don't think that, because it has to be, if there's no decision, the trial goes then. So the appellate courts, there's just 2 layers. There's the D.C. Circuit Court of Appeals, which would hear the appeal from Judge Chutkan's order that this trial has to go, and it's going in March, and I'm not moving it. They would go to them. They would get a decision. Let's say they went in January. They get a decision well before March 6th. When it's supposed to start. And then let's say they got that decision on February 20th. Then there'd be an emergency request to the U.S. Supreme Court to issue a stay. And then if they issued the stay, then they might explain their decision later. But they wouldn't wait that long, the U.S. Supreme Court, because imagine the whole nation expecting that trial to go in early March. And then all of a sudden the Court of Appeals says, yes, that is when it's going. And then there's this appeal to the Supreme Court. The Supreme Court wouldn't have to take the case. But if they made a good enough record, I can see that 5 or 6 justices on the U.S. Supreme Court saying, or maybe they wouldn't delay it all the way till after the election. Maybe they would say, okay, you guys have shown you need 3 more months. They delay it 3 more months and then expect that whole thing to repeat itself. And it could go. I mean, it's a real, that one, I'm not making a prediction. What do they call that?
Well, you think that, but you said if it goes to Supreme Court.
Sports, even, just
yeah.
no pick. No pick.
You said if it goes to the Supreme Court, you think it's probably a 5-4 decision for Trump, though, you were saying.
I look at the votes. There's
right, of course, yeah. It's a stock, it's a stock.
I come from regular stock.
Yeah, you've got Clarence Thomas and the crew, right?
The one he sometimes loses is Chief Justice John Roberts. But the people who are really cynical and think that Barrett, Kavanaugh, and Gorsuch are the 3 that he nominated for the U.S. Supreme Court. I know that's a very, very cynical view of things. It's one expressed by Trump. It is so distasteful to how our courts are supposed to work and the rule of law. But again, betting money, like I said, they won't say we did it for Trump. They'll say we did it for the Speedy Trial Act, for American, justice, liberty, that people need to have time to go to trial. And this is actually a fast, if you look at it, Mark, this is fairly fast for such a complex case with 3 different conspiracies. If this were a you or me, God forbid, we would probably have more time than Trump had. We'd probably have over a year. You look at some of these famous cases, they have taken 2-3 years to get to trial. I'll tell you something else, which is interesting, though. I thought this issue might come up, in many different forms. And so I looked it up. It's actually surprising how fast some of the big cases went to trial. The Watergate cases actually went to trial pretty fast. And some of the cases with senators and Congress members. But one of the reasons was that they wanted the jury to say not guilty or to hang before their election. So they themselves were okay with a fairly speedy trial. But Trump will do everything on God's green earth to delay that trial.
Well, the last thing I'll say, and then I want to hear from Kim, but the last thing I'll say is that he has raised money off of this like nobody's business. If you look at what the money raised constitutes to this point, these are scary numbers. Donald Trump loves being this embattled victim-like figure for fundraising purposes. So he's playing that as a sideshow as well. Go ahead, Kim.
Can I say one last thing, Kim, before your
please.
comment? Just one last thing.
Yes,
I won't remember the joke. I won't remember the joke. I'm sorry. But if I were representing Trump, which I never would, and somehow I tried that January 6th case and the jury said not guilty, I guarantee you Trump would whisper in my ear, "What's wrong with these people? How stupid are they?" He knows in his heart and mind, and then he said, not that deep, right on the surface plus deep inside, he knows in his heart and mind he is so guilty of January 6th that it's not even funny. Go ahead.
Can we start a GoFundMe for good bribes? I mean, vacations for the Supreme Court judges, right?
Yeah. Hey,
That's
fight
from
fire
Russ.
with
Go
fire.
ahead. Yeah, go, Kim. Sorry.
I just wanted to ask you about the Joran Vandersloot thing from yesterday. And basically, he was being charged with fraud and something else for allegedly trying to extort money from Natalie Holloway's family for information about where the body was dumped or what happened to her. It turns out that he enters some type of settlement agreement with them, or plea arrangement, where he pleads guilty to the fraud charges, but in doing so has to say and admit, yes, I killed her, and here's where I dumped her, and here's how I did it. Does that mean he's never going to be held accountable for the actual murder? Because the information of getting to what happened to her, where is she, is more important than the holding you accountable for it?
I haven't followed the case that closely, but I know that the family was, of course, extremely distraught. I mean, that doesn't begin to capture it. Then they really wanted to know what happened to their daughter, this person that they loved. So they were okay, I believe, with this disposition. And if a victim's family says, we're okay with this disposition, as a prosecutor, it's like, are we really going to push it further? Are we going to push this case to a trial down the road because the defendant won't agree to such and such? But the family's okay with it, the defendant's okay with it, we're not okay with it, so we're going to force everyone through a traumatic trial. So I think that was part of the calculation. And again, I don't know the case I know it happened outside the United States. I think he was not a U.S. citizen.
Right.
It may be that killing a U.S. citizen anywhere gives you federal jurisdiction over the murder, but it's certainly a legal issue that would have come up. And again, I think if the family was okay with that disposition, he is serving something over 20 years in Peru for the murder of someone else, which of course assumes that he murdered her, but he admits that he murdered her. He was demanding sex. She didn't want to have sex with him. He became furious, freaked out, killed her, dumped her in the ocean. That's his confession.
Yep. Yeah. And that's that.
No,
I think that
the judge noted the confession.
A lot of time in Peru, in prison in Peru.
Yeah.
That's not a good place to be in prison, but it's where people who murder people belong. You've changed the course of our lives, said her mother, Natalie's mother, and he was mentioned. What he did was mentioned in the judge's remarks. You have brutally murdered in separate instances, years apart, 2 young women, and he goes on. It's a troubling case, but that was interesting. I wondered about what also were the effects of his confession and his plea agreement. Now I want to ask you, David, in closing, about the ghost gun decision. There is in this United States of guns, it seems as though any gun, any weapon, however it's fabricated, however it's put together, wherever it comes from, is protected. Can you speak to the ghost gun decision?
Yes, it's really fascinating. Imagine that you had a wheelchair, and instead of selling the wheelchair as a wheelchair, you sold the wheel separate from the chair, and all you had to do was screw them together. Okay? So the ghost gun's really not a great expression. They're just guns that have different parts, 2 or 3 different parts that you screw together. And once you screw them together, guess what? You have a perfectly serviceable firearm that expels a projectile, an explosive, and that can kill people. But if you put the wheelchair together, if you put the 3 parts of the gun together, then you have to put a serial number on it and it becomes traceable. So these manufacturers of these ghost guns have this great commercial idea that they're going to sell it in 3 different parts, and then they don't have to put a serial number on it or anything else because it's not a firearm. The government said it is a firearm, and you have to put a serial number on it, and you have to make it so that it's traceable. You put the serial number on each one of the 3 parts. So the gun lobby, and especially these 2 manufacturers of these firearms that just come in 3 parts to assemble, went to their favorite judge. This judge his name is Reed O'Connor. Believe it or not, he worked on the Senate Judiciary Committee, I guess, for the Republicans, and he was a nice guy. Everybody liked him. So they approved him by a voice vote. I mean, Leahy, Feinstein, Bernie Sanders approved this fellow on a voice vote. And there he sits in the Northern District of Texas, and he's issued one terrible overturned ruling after another. He is the same judge, Mark, who struck down Obamacare and freaked everyone out until Obamacare went to the U.S. Supreme Court, and they said, of course it's a tax. Forget the Commerce Clause, it's a tax. Chief Justice Roberts made that famous decision. But until then, he'd issued a nationwide injunction purporting to knock out Obamacare. And he's issued a bunch of other decisions that are far out and that got reversed. So he issued the first decision in this case that, as I said, this was not supposedly a firearm. It went to the Fifth Circuit, which is another subject that we should talk about. Will bore your listeners, but they affirm these decisions. They affirmed Obamacare. They affirmed the medical abortion pill case. This is that Fifth Circuit down there in Louisiana.
Oh, so this is a good place to be, maybe, for the appeal of this decision,
it's
or not?
so Trumpian. Well, so they affirmed this judge, and it went to the U.S. Supreme Court. Now, the U.S. Supreme Court took the nationwide stay off. They said, we are not going to have a nationwide stay. The federal government can treat this as a firearm. They can demand that people put what I'm talking about here, the
serial numbers on
put the serial numbers on all 3 parts. The federal government can do that. The Supreme Court said that 5-4. Scary. Kavanaugh didn't think that if you make a wheel in a chair with a screw, that it's a wheelchair.
Wow.
They didn't think that this was a good. So Kavanaugh ruled that you didn't have to put the serial number on the 3 parts. But luckily, Amy Coney Barrett went with Chief Justice Roberts to have 5 votes. So they sent it back to the district judge, and they say, okay, now do what's sensible with this case. Now that you know that it is a firearm, it has to have a serial number. The 2 manufacturers that make it said, oh, wait a second, this doesn't apply to us. This nationwide injunction, but we have special reasons why we need to market this. We're going to go bankrupt if we're not allowed to market this. You got to put the stay back on. And this judge in this Northern District of Texas judge said, oh, my goodness, you would be harmed. You'd be going bankrupt. Oh, my goodness. You too. All didn't mean all. All apparently meant all, but you two. And he said that here's the injunction for the 2, which meant you could still buy it without a serial number from the 2 people who actually manufactured it. It totally undercut the injunction that the taking the injunction off by the U.S. Supreme Court. That was not enough for the Fifth Circuit. The Fifth Circuit said, beautifully argued, yes, all but 2, all does not mean all but those 2. The Fifth Circuit said, the U.S. Supreme Court, bless their souls, on Monday unanimously said, basically, that you're defying our order. You got to go back to reading comprehension 101, district court judge down in Texas, and they overruled him 9-zip in a short order. But that's what's so confusing about it. And so the reporting on it was terrible, including on Fox, which I think said something like, Supreme Court falls for Biden administration gun argument. They didn't fall for anything. It was 9-0 to do now exactly what they ordered be done last summer. And that's why people have deja vu when they see the decision, because they think, I know, wasn't this decided already? Yes. Yes to the Fifth Circuit. Yes to the district judge. This was decided already. You don't get to countermand the U.S. Supreme Court.
So at the end of all of that, as the dust settles, the requirement will be for serial numbers on those parts, those distinct parts of the gun.
That's the law right now, and thank goodness, because as the administration pointed out, these ghost guns, as they're called, these guns that you just put together, and so they're the ones that are used by terrorists. They're the ones that are used by criminals. They're the ones that are used by people who don't want their use of the gun to be traceable. Anyone who's using it for a legitimate purpose would have no problem with it being traceable. They haven't done anything wrong. So yes, the quote ghost guns now are traceable. They have serial numbers, and for all, I know you don't have any listeners who are terrorists or criminals, but for any who might hear this somewhere, you will get caught. You will get caught because there'll be a serial number even on the ones that you assemble.
Yeah, which is the way it should be. David, thank you. Love your takes. We covered a lot of territory today, and I appreciate it very, very much. You can find David across the spectrum. He's a working lawyer, defense lawyer, but wow, you are so good to give of your time to those British people who always have you on in London and across the cable universe, and just really, really cool that you spend time with us too. We appreciate it. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.